Greetings to one and all present. My name is Ankit Malhotra. I am an advocate and a Felix scholar based here in India. I would like to also thank the organizers for giving me an opportunity to share my thoughts, albeit in this online virtual mode. I would have loved to be there in person with everyone. However, time, work, and financial constraints do not allow one to participate as one would have hoped. With that introduction, I would now like to proceed with discussing this topic on international family law from a, shall we say, a public international family law perspective, which looks at two countries and their jurisprudence on international family law issues, but perhaps more specifically look at the United Nations Convention on the Rights of the Child and its celebration of 35 years of existence. But the application of this international law into domestic systems, two systems which perhaps breed from the same umbilical cord of the empire, but two systems which have fared rather differently in terms of its international law obligations. One adopting conventions wholeheartedly and then wrestling or engaging with them in their domestic system, this being the United Kingdom, and rather disproportionately in the other side, India, which has chosen to choose its steps towards conventions in a much more conservative manner, provides for an interesting reflection point, and that is the aim of this paper as well. It offers a sort of a preliminary reading of international child law litigation in these two countries. With that introduction, I'd now like to proceed to discuss issues in the Indian system and more specifically look at how the Indian jurisprudence has evolved over the years. But perhaps before I do that, I'd like to specify that uh, the Indian system, or at least the Indian diaspora, is massive. It expands to 3.4 million non-resident Indians who are registered as overseas Indians or overseas citizens of India in the legal parlance. They acquire this lifelong visa-free entry into India, and they're spread across all parts of the globe, perhaps some even in the parts of the globe where this August gathering has assembled. But the link and retention of their ties continues with the extended families in India, but have still found an expression of issues related to nationality, citizenship, marriage, divorce, spousal maintenance, alimony, interparental child removal, custody, and guardianship of children. Having said so, issues related to, say, for instance, dual nationality, passports, and citizenship, or also problems of wills and succession, need solutions. In such circumstances, foreign courts and Indian courts have to resonate with one another. What therefore happens is a conflict of laws, and a parallel and simultaneous adjudication in different systems creates an anomalous situation which compounds legal dilemmas, relationships to humans with one another, and perhaps most importantly for us as legal scholars and advocates of the law itself. But the application of these foreign laws and the validity of judgments pronounced overseas and verdicts of Indian courts need exposition and consequential issues relating to interpretation and expert opinions from both systems. All Indian laws germinate from the Indian Constitution, and that is a peculiar function in comparison to the English system, which does not have a written constitution. Having said so, the Indian Constitution is conservative as well. For instance, it does not allow citizens to have dual citizenship, and a child born, say, for instance, to foreign citizens of Indian origin cannot be a citizen of India, as neither of his parents are Indian nationals. Therefore, only by amending the constitution, a new category of citizenships, that is, the overseas citizens of India, which I mentioned earlier, was created in 2005, in some sense a compromise to dual citizenship, but with limited privileges and no rights of Indian citizens. But the Constitution of India and, say, for instance, the Citizenship Act of 1955 categorically prohibit dual citizenship and holding of two nationalities at the very same time. So, therefore, what about Indians, foreigners, and also systems of deportation and immigration? Well, India, in that sense, also has archaic laws made during its colonial eras, but they have stood the test of natural justice and conferred unfetteredly, but have maintained their draconian principles ever so. In so far back as 1967, a comprehensive and wholesome law relating to issues of passports, travel documents, and statutory safeguards provide a procedure for variation, empowering the revocation of passports with rights to appeal to aggrieved persons against offences and penalties levied under the Passports Act. However, simultaneously, existence of passports, say for instance, for entry into India in the 1920s and in the 1940s, confers an absolute and unlimited power to remove or deport a person from India summarily without the process of law as serving an anathema, an antithesis to the rule of law in a democratic nation with ample scope for judicial review. Today, persons of Indian origins might have relations with respect to matrimonial differences between spouses of global origin or nationality, but issues arising out of foreign domiciles need to be answered. Accordingly, deportation or removal of a person to a foreign jurisdiction would be an abject surrender to foreign dominion. What about child and child law? According to the UNICEF, India has over 30 million orphan and abandoned children. Initiatives by the Supreme Court of India after 1984 led to the amendments to our juvenile justice system. More specifically, the Juvenile Justice Care and Protection Act of 2015. The rules laid down in 2016 and the statutory adoption regulations, also of 2017, were amended in 2021. These followed to create the Central Adoption Resource Authority as a statutory body to regulate, monitor, and control all intra and inter country adoptions. Furthermore, the role of CARA became pivotal in granting an NOC, a certificate essentially of no objections to countries for intercountry adoptions. According to India and the system mentioned in the legal treaties, India is a signatory to the Hague Convention on Protection of Children and Cooperation in respect of intercountry adoptions. India is also a signatory to the United Nations Convention on the Rights of the Child and protections offered to children that became a legal mandate for all authorities and courts in India. This was done through the incorporation of the JJ Act, which is now a secular law. At this point, perhaps it is also important to reference that India does not have a universal civil code. Rather, secular laws based on religious values take dominance. The JJ Act, nonetheless, is a secular law, thereby having an application on all persons. All persons, therefore, are free to adopt children under the JJ Act. However, persons professing the Hindu religion are free to adopt also under the Hindu Adoption and Maintenance Act of 1956. Rehabilitation of all orphaned, abandoned, and surrendered children is regulated strictly by the mandates and procedures of the adoption regulations laid down under the JJ rules of 2016. Children of relatives can also be adopted under the JJ Act if desired. Only such children declared legally free for adoption under the JJ Act by prescribed procedure can be adopted. Any person or organization offering, giving, or receiving such children for adoption in violation of the JJ Act and adoption regulations invites punishment up to 3 years and a fine up to 1 lakh rupees, which would be equivalent to £1,000. But what about the removed child and the law in this context to India? child custody, and the vexed question of cross border interparental child removal not find any legislation defining them. Therefore, the subject remains varying to judicial interpretation by the Supreme Court of India time to time. India is not also a signatory to the Hague Convention on Civil Aspects of Interparental Child International Child Abduction 1980. This convention has been acceded to by 105 other countries. Thus, therefore, wrongful removal and retention of a child by a parent defy recognition and acceptance under codified Indian law, even though the offense might be intentional. For the corpus of 30 million NRIs living all across the globe, the multifarious relationships create an immense potential for unresolved children in disputes upon relocating to India by violating the other parent's rights in a foreign jurisdiction. That is not all, because under the Hindu Minority and Guardianship Act of 1956, it declares that the natural guardian of a Hindu minor boy or an unmarried girl shall be the father, and after him the mother, provided that the custody of a minor who has not completed 5 years of age shall ordinarily reside with the mother. The law also does not contain any precedents or statutory or procedural mechanisms for adjudication of custody rights or declaring the court appointed as guardians. The reference to the word court here in the convention, in the Indian law, relegates a parent or any other guardian seeking appointment as guardian to invoke the provisions of a 130-year-old colonial law, the Guardian and Wards Act of 1890, and wherein the parent is constrained to seek exclusive temporary custody of his biological offspring during the pendency of such hearings. Be that as it may, and as sad and unfortunate as it is, child custody issues between parents are thus to be determined by the Guardian and Wards Act upon a natural parent wanting to be declared as an exclusive guardian to his natural born child. Having said so, coming back to the United Nations Convention on the Rights of the Child, the definition of the best interest of child has been implanted into the JJ Act, the Juvenile Justice Act, as was mentioned and discussed earlier, and it has been incorporated as follows: as to seek the basis for any decision taken regarding the child to ensure the fulfillment of his basic rights and needs, identity, social well being, and physical and emotional intellectual development. Courts in India are therefore bound to ensure the true import of this meaning to its expression. However, only under the writ of habeas corpus, which is to produce the body in the court for seeking implementation of child rights, is the only way out. Since where the parents are fighting for the custody of the offspring is settled in a case in the 1960s by following the principles applicable to English writs to deliver the custody of infants. Only in 2009, again relying on English judgments, the Supreme Court held that the basis for issuance of a habeas corpus in a child custody matter is not illegal detention, but the primary purpose is to furnish, by a means which the court determines necessary in the exercise of its judicial discretion, may be to determine what is the best welfare of the child, and the decision is reached by a consideration of the equities involved in the welfare of the child, against which the legal rights of no one, including the parents, are allowed to militate. Only in 2019 the court took expression that the best interest of the child is given in the JJ Act, and a child centric jurisprudence held that it cannot remain the love and care as the primary factor of just the mother. Thereby, the courts, in its wisdom, shattered the glass ceiling of a gendered perspective and preference, provided the neutrality to its parents on the welfare of the child principle. Not so long ago, Perhaps 2 years ago, 2 years before the judgment that I just referenced, Justice A.K. Sikri held in a case in uh, in the Delhi High Courts, referencing the psychological impact that one faces in reference to the parental alienation syndrome, wherein Justice Sikri held that a child centric human rights jurisprudence has evolved over some time and is founded on the principles that public goods demand proper growth of the child, who are the future of the nation. The law declared by the Supreme Court shall be binding on all courts. In the absence of a clear codified law on cross border interparental child removal issues, the much needed clearer path of jurisprudence and precedent will continue to guide litigants and courts. Having painted a rather unfortunate yet true picture of the Indian system, it is at this point that one feels necessary to jump across the oceans and continents and look at the English system. Insofar as the English courts are concerned, especially with respect to the relocation and wrongful removal of children, it is important to now remember that in a globalized world with more and more international families, these issues are becoming common. Upon the breakdown of marriages or relationships in what is now known as the divorce capital of the world, one of the most natural and compelling feelings can be for a parent to want to return home, particularly if they have been living in a different country for work or for reasons connected with the spouse or partner, resulting in relocation and wrongful removal of children. A nuance of the English system is the construction of the word domicile. Now, this is very subjective, as we have all different domiciles of origin where we are born, but this can be flexible and changing over time as to where we reside. Additionally, we can have a domicile of choice, that is, where we want or choose to remain permanently or indefinitely. These legal constructions have a real prominence, particularly in cases of surrogacy, where currently one of the criteria for granting parental orders is that the intended parents is domiciled in England and Wales. Having said so, it is important to consider the meaning of the word home, for a child can be complex, and the legal concept of habitual residence is very relevant in this regard, particularly in wrongful removal cases. In relocation cases, for instance, comparing with other jurisdictions, the Court of England and Wales has been ready to allow children to go back to their region of countries. This has caused some controversy in the past, but because of societal norms shifting and are seeing much more balance and equity in parenting, it is thought that it is probably becoming less likely than before that a court will allow a child to relocate when opposed. That said, in an application, in an application of any kind, it is considered the best interest of the child as perhaps the most determinative factor. But what about litigation in respect to the United Nations Convention of the Rights of Child, particularly in relation to the welfare and the best interest of the child? In a case decided as far as back as a decade ago, the Supreme Court of England and Wales held that the emphasis and the importance of considering the welfare of the child is paramount, which is a principle established in Article 3 of the UNCRC. Such judgment also reiterated that the courts must consider the best interest of child in all decisions affecting them, reflecting the UNCRC's influence on domestic child litigation. In another case, the Supreme Court held that the significance of Article 3 of the UNCRC, stressing that the interest of child must be a primary consideration when making decisions affecting children, particularly in immigration cases. The courts also reflected on Article 12 of the UNCRC, which emphasized that the rights of the child must be heard in judicial proceedings. At this end, one must caveat that the child's considerations are neither entirely or wholesomely determinative or entirely just procedural. Having said so, I also want to reflect on another matter decided in 2012, wherein the parental responsibility and residence were considered as issues of importance. The Court of Appeal made explicit references to the United Nations Convention, the Rights of the Child, reinforcing the best interest of child on litigation on such counts. It reflected more specifically on Article 9 of the UNCRC, which spoke about the child's right not to be separated from their parents unless it is in the best interest of the child, which was the court's central analysis. In another matter, the court considered Articles 26 and 27, which relate to the child's right to social security and adequate standards of living. The case underscored the state's obligation under the UNCRC to protect the children's rights and socio-economic context. However, what must again remain important as a reflection is perhaps Article 12, because the rights of the child to express their views in family proceedings is linked, as I had shared earlier. The Court of Appeal in England and Wales must highlight that the child should have the opportunity to participate in decisions affecting, well, exactly them. And the views that they, they share must have relevance, considering in accordance to the age and majority that they have. Having mentioned these different cases and systems in the English side, what I've tried to illustrate is the growing significance of the UNCRC in shaping child litigation in the United Kingdom, but perhaps more particularly, the interests of the child prioritizes the legal decisions and the children that are given a voice in proceedings affecting them. The influence of the UNCRC is evident and shows how the English courts continue to incorporate international child standards into domestic jurisprudence, which perhaps in some sense will stand at crossroads with the Indian system that considers itself to be determinative or sufficiently strong to determine these. To conclude, I want to reflect on something which has caught my attention while I prepared for this paper. What you see on your screens is a waterwork by executed in the 1980s, which reflects the Maharajas of two states in India, and in fact three states in India, along with a British officer. The three royal officers belonged to a princely state, to different princely states, which had entered into subsidiary alliance with treaties with the East India Company, therefore losing their sovereignty to the English Empire. In the work, one can see this reflection quite clearly. And it is also important to bear in mind that the auction of such rights is important because such auctions reflect the intersection not only in art but also in law, that issues related to child law, for instance, reveal a complex legacy of systems that have shaped contemporary frameworks in both jurisdictions. Indian family law, for instance, is deeply influenced by its colonial past and retains elements of archaic legislation that continue to govern the personal matters of child custody, of divorce, and perhaps also of marriage. These colonial laws were developed by the British, but often fail to accommodate the modern realities faced by millions of non resident Indians with which this paper started. For instance, I must recollect the outdated statutes like the Guardian and Wards Act of 1890 are still invoked in child custody issues in India. Despite their limitations in addressing cross border disputes that affect millions of persons aggrieved by disputes by one party or one parent. Similarly, in England, The evolution in family and child law, particularly through its post colonial reforms, highlights the need for modernization in approaches to family justice. The UNCRC for them has played a pivotal role because it has allowed them to reshape the litigation in these English systems with an emphasis on the best interest of child, a principle which is now firmly embedded in not only the English system but also in the Indian system. However, the lingering presence in India of the colonial laws creates inconsistencies with modern international standards, which are perhaps enshrined most predominantly in the UNCRC, especially in cases which involve child border abductions or custody disputes. The absence of a comprehensive legislative framework to address these issues in cases of child abduction leaves Indian courts reliant on judicial interpretation rather than codified law. The contrast between these two jurisdictions, while rooted in shared colonial past, is marked by the United Kingdom's gradual incorporation of international standards. The courts and these cases have emphasized the primacy the child's welfare must take, aligning the English courts and systems with the UNCRC. And to this end, I want to again reflect in contrast that while referencing the UNCRC in the Indian system, principles often have struggled with the outdated colonial legislation hampers the full realization of these rights, especially in the context of international legal frameworks. To that end, I would like to conclude with saying that as India grapples with these challenges, there is an increasing need to reform its family laws and systems to reflect contemporary realities and uphold the system of rights enshrined in international legal instruments like the UNCRC. Such reforms will not only modernize the legal system, strengthen its capabilities and abilities to address complex frameworks, but also allow the strengthening of issues of this global diaspora. But it would not stop just there, as it was also allow the bridging the gap between its colonial legal heritage and also the demands of a globalized world. With those words, I'd like to now conclude and once again thank the organizers for giving me an opportunity to share my thoughts. I once again apologize to the organizers for not being able to be there in person. However, there is always a next time, and I do hope to continue this affiliation with the society. Thank you very much.